Hello and welcome to the first of 4 educational mini-series provided by the Berks County Area Agency on Aging. My name is Ann Barlet. I'm the Manager of Community Outreach and Education for the agency. Our first mini-series is on retirement planning. There are 4 segments to the series, and today's segment is going to be focusing on estate planning. My guest this evening is attorney Bob Kreitz with Roland Stock Law Firm. Welcome, Bob.
Thank you, Ann. It's a pleasure being here.
Thanks. All right, I'm going to start right in with estate planning. And when I think of estate planning, I think, oh my gosh, I don't have an estate. So what constitutes an estate? And then what are some of the things I need to prepare for? And as I'm looking at retirement, what should I have? What should I do in terms of my estate and estate planning?
Okay, estate planning can be a more or less intimidating term, and I believe it sometimes results in people really not doing anything because they are really intimidated by that term, or they think, as you just stated, well, gee, I don't have that much of an estate, I just have a house and some bank accounts, some basic assets, so I don't need all of that fancy estate planning. Well, the truth is that everyone really needs some type of estate planning because on a basic level, all estate planning really is planning what happens to your assets either after your death or, very important also, is if you would become disabled. If that's the case, again, you need to make plans up front for that. So estate planning can be as simple as preparing 3 basic documents.
Okay, so as you said, in preparing, so now you've made it a little less anxious in terms of thinking about an estate and planning. So if I'm planning ahead, looking at all kinds of things upon retirement and considerations in retirement and estate planning, I guess I want to make sure a couple of things as I look at as I look at 3 documents. I want to make sure that I know, are they legal? First of all, what are the 3? Let's just start with naming the 3, and are they legal documents?
Right.
In other words, I need a lawyer to do.
Right. Yeah, those 3 basic estate planning documents that really virtually everyone needs are a basic up-to-date will, a financial power of attorney, and a healthcare document, which normally contains a healthcare power of attorney and living will. Those are your 3 basic documents. Again, from there, all of estate planning is very fact-specific, and there may very well be other things that are needed depending upon the individual or the couple's situation, their financial situation. But those are your 3 basics.
Okay, so we've got wills, power of attorneys, and living wills.
Correct.
Okay, so they're all legal. I see a lawyer to design them, draw them up. If I don't, okay, I'm going to go back to what if I don't? Here I am today, and I intend to, I plan to, but I don't happen to. So what happens with my few assets, home and whatnot? Does the state then get them because I didn't?
That's a very common statement, and that's really starting out with the will. I still get questions constantly from individuals, clients, when I'm speaking to groups or individually, saying that if I don't have a will, does the state take all my assets? And the answer is no, the state does not come in and take all your assets, but what happens is the state will in effect make your will for you under what we call the Intestate Act. And what the Intestate Act is an act, Pennsylvania law, that basically gives you degrees of relationship. For example, if you don't have a will and you're an individual with a spouse and children, basically your spouse and children are going to share that estate. There's later it would be parents, siblings, grandparents, uncles and aunts, nieces, nephews, first cousins, and only if you do not have any relationship or any living relative closer than a first cousin would the state possibly come in and be your heir. And as I've stated, I've been practicing law now, it's hard to believe, for 36 years, and I've actually only had that happen one time, where there was no will and absolutely no one to take the person's estate.
And if you can explain then for me, we talked about the assets in terms of house and car and things like that. Explain how things that I might have through my 401k or other things that I've done financially, right. How does that relate to the beneficiary of that versus the things I leave to folks in a will that
That's a very good question, Ann. And this is also a common misconception people have. you should definitely have a will, but that doesn't mean everything you have passes under your will. Frankly, many things today do not pass under a will because they are either jointly owned, with a spouse or child or someone else, or they have an actual beneficiary designation on them. For example, most life insurance policies have beneficiary designations. That does not pass under the will. Most employee benefit plans, it's highly advisable for tax purposes, income tax purposes, to name beneficiaries on your IRA, your 401k, things of that nature. So those things would pass based on the beneficiary designation, notwithstanding what you would have in the will. And that's why it's very important for an estate planner to understand what assets a person has, so they understand the way things are going, not just under a will.
And we talked before this taping in, I always picture when they say about reading a will, and I picture the TV shows where there's a murder mystery and they gather everyone around and they say to so-and-so I leave my collection of this, and to so-and-so I leave the manor or estate, and so on. How does that all work in terms of designing? What am I putting in? How am I designing a will?
Okay.
Or how are you helping me?
And in that, and then around in the movie, the disgruntled heir gets up and storms out of the room. No, that usually doesn't happen. What happens is this. Generally speaking, after death, usually sometime right after the funeral, maybe within the week after the passing, the family, particularly the executors, and other family members are always welcome too if they'd like, meet with me in my office and we go over everything that needs to be done in the estate, and then I will need to take them over to the County Register of Wills office to actually get the executors sworn in and get things started. So that's really the estate procedure. Normally then what we would do is for any what we call residuary beneficiaries, people getting shares of the estate, they have a right to know what's in the will, and they also have a right to know what's in the estate. So normally we would send a copy of the will out to them.
Okay. And so we were mentioning in terms of, do I leave specific things? Maybe I have a collection of something that my grandchild admired, and I want to leave that particular collection to that person. Do I itemize all kinds of things?
Yeah, you can do that. However, I usually recommend that a person not list every one of their individual plates and dishes and TVs and chairs and computers specifically in the will. Because normally, unless you have a family situation which you think may be contentious, I would generally recommend leaving things in shares and then letting your children, or whoever the heirs are, assuming they get along with one another, work it out among themselves with what they want. Because a lot of times what you may think a person wants, they may really not want, and somebody else may prefer that. So I prefer to be more generic in that regard. There are different ways to handle personal property, but that I think is generally the best way if the parties agree to that. One of the other things you had mentioned, and I alluded to, was leaving your assets in shares.
Yes.
And I think I will tell a little story here, if I may.
Sure.
And this was a will that, first of all, I want to clarify to our home viewers, was not written by me or my office. But this was a will of a lady who, when she made her will, thought she had somewhere around $50,000 of assets. What she did was she said, I have 4 nieces and nephews. I'm going to leave $10,000 to each of my nieces and nephews, pay all my bills, and if there's anything left over, leave it to a certain charity, which I'll leave unnamed. Well, I explain this when I speak to groups a lot, and I always ask the audience what happened. So I'll ask you what happened. In this regard, she won the lottery, and as a result, each individual niece and nephew received $10,000, and the charity in question received $385,000. Now, I don't think that anybody felt those were her desires when she made that will. What she should have done was, if she wanted to leave something to a charity, that's wonderful, and I always encourage charitable giving. She should have left them a specific amount and then divided her estate into 4 equal shares, so that no matter what she had when she passed away, whether she had $10 or $10 million, it would be divided 4 ways equally. So again, that's the proper way to do it.
That's good. That's a good advice to think about when we're moving forward.
Correct.
And trying to figure out what's going on. I think what in that example too, my next question would be also, because she had that change in her income or had that nice fund, lottery fund, are wills then changeable, or how can I do it when I want to? Should I come into a windfall and I want it divided that way and changed? Or even, let's say that those 4 children that she had designated, or nieces or nephews, and one dies. So, you know, we might need to update.
Sure.
We can do that. Right?
Absolutely. Updating wills. Wills are irrevocable. You can change a will anytime as long as you have what under Pennsylvania law is called testamentary capacity. That means you understand, you know, who your heirs are, basically what you have, and you have the mental capacity to change your will. And again, I always encourage people every few years, and for some people even more than that, depending upon the complexity, going in and looking at your will and your other estate planning documents and make sure they still make sense to you. And again, that's very important. I recall another situation where I had an individual, a widower, and he had 3 children, and he had a lady friend. And when he passed away, the children came in to see me, and the will was divided in 4 equal shares among the 3 children and the lady friend. The children were very upset, though, because it seems like the lady friend took off with some other gentleman as soon as their father got ill. So they wanted to contest the will. And I asked them one question, and that is, did your father understand what he was doing when he made his will? And they said, yes, he did. And I said, well, then you really have no case, because the problem there was not what was in the will. He had capacity, he made the will. The problem is the will should have been changed, and he didn't do so, and that can be a problem.
And is there a right time and a wrong time? We mentioned this at the beginning about when one should start doing a will. You know, as I'm looking ahead, you know.
Yeah, I've written wills in my career for people ages 18, and of course you have to be an adult of age to have a will. Anywhere from 18 to, I think my record is 104 right now, and could get older, who knows, as I have more and more centenarian clients. So I encourage anybody to have a will, because even if you don't have much of anything, or you think you don't have much of anything now, down the road you may inherit, you may receive assets from one way or another, and then at that point you will have something that you want to dispose of. And I think probably even more important than having a will is having our other documents. I don't know if you want to lead into those now, Ann, or not.
Sure, let's go on. You mentioned, so we talked about the will. The next piece is, I believe, the power of attorney. And
correct.
And I think it's we mistake that as that we are the power of attorney, in that it's a document.
Correct.
So explain to us please clarify for us, what is a power of attorney document?
A power of attorney is a document which creates what's called an agency relationship in the law. You have an individual we call the principal that wants to allow someone else, an agent, to do things for that person. Now, and again, you need a specific writing to do that. There are general powers of attorney and there are specific power of attorneys. An example of a specific power of attorney, I would say, is, Ann, if you get tired of the Pennsylvania winters and decide to retire to Florida or let's say Arizona, you may choose to sell your home, and if you want to leave before winter, you can designate me or someone as your limited power of attorney or special power of attorney to do nothing except handle matters pertaining to the sale and settlement of your home. Once settlement is over, once we sign the documents, wire the funds to you, that power of attorney would end. Another example of a limited power of attorney is many people will come in and I'll ask them, do you have a power of attorney? And they'll say, oh yeah, I signed it at the bank. Well, all that means is they signed a form allowing a child or someone else to have access to that particular bank account. That in no way suffices with what you need as what we call a general power of attorney. I believe in having very broad power of attorneys because, again, you never know what you need.
And what we hear before we talk about the types of power of attorney documents, so a lot of the times when we're out doing community fairs or right now we're participating in an aging parent fair, which encourages the adult children of seniors to be able to talk with them and work with them about their needs, but also we're talking to the adult children, you and I,
right.
About preparing for ourselves. So
exactly.
When do we need a power of attorney
Okay.
also, you
There-
know, and maybe that'll be best explained with the types,
Yeah,
you know.
that's a very good question. There was a time when I first started practicing law that I was really focused on preparing power of attorneys for older individuals. I'd say maybe 55, 60 and up, although that's getting younger. That's getting younger and younger, frankly.
Yeah.
But a couple of things changed over the last, say, 30 years. One of them was all the Privacy Act issues. There was a time, and I'll say this to clients, and they actually get a nice laugh out of it, where I could actually call a bank and say, I'm doing work for Ann Barlet, can you please tell me what's in her bank account? And they'd say, sure, Bob. I don't know if anyone thinks that I could get away with that today. They'd probably think I was crazy if I even tried. Again, with all the Privacy Act implications, the only way I'm going to get that information is to be a power of attorney for that individual. The other issue we talked about a little bit on the will side, and that is the type of assets that exist now are so often assets which are not the typical joint real estate or joint CDs or joint bank accounts or stocks owned by husband and wife. The wealth of the nation for most individuals, I'd say about 60 and younger, maybe even more than younger, is in 401k benefits, IRA benefits, and those are individually owned assets. I've had people with rude awakenings when, for example, one spouse gets ill and the other spouse calls the IRA company, 401k provider, etc., and says, I need information about this account. And they tell him or her, well, we can't provide you with that. And indignantly, they usually say, well, I'm the beneficiary. And they'll say, well, that means nothing other than the fact that someday you're going to get a check. So again, you need a power of attorney now for all of those things. And again, I've written power of attorneys for some of our young heroes who've joined the military and are deployed overseas. And I've made power of attorneys for centenarians. So I think right now everyone should have a power of attorney.
And when I'm designating somebody for me to be my power of attorney, tell me when do they begin to do things that they can do with that privilege?
Well, they are able to act immediately because I don't care to, I've done them a few times in limited circumstances, prepare what we call springing power of attorneys. A springing power of attorney only, I guess the term is used because it springs up upon the happening of a certain event, such as a disability or something, and then the person can act. What I find, you're much better off having the power of attorney ready to act at any given time so that if an emergency does come up, you're able to do it. And again, you oftentimes, as a child or as an agent, aren't only acting for someone if they are disabled. I recall very well that I was very fortunate that my parents were snowbirds and they owned a home down south in the winter. So while they'd be enjoying themselves down there, I would be up here paying the bills for them from their bank accounts in the snow. And they were perfectly capable of doing that themselves, but since I was their power of attorney, I was able to handle that. So again, it's very important, as mobile as people are, if they're called away on business, they're overseas or whatever, to have somebody designated to fill in for you at any time.
And I'm thinking that is example in terms of even a husband and wife who are retired or semi-retired, one is, and they go away a lot, and something happens to one of them on vacation or while they're away, and the other one then can move right in and do.
Yeah.
Okay.
That brings to mind, too, a question as far as should there be more than one power of attorney?
Ask you that, yes.
Yeah. I believe there, and again, if you ask different attorneys, you of course will get different, preferences based upon, their particular ideas and experiences. My experience is if you have children or agents that get along with one another, you're better off having multiple agents. However, I always do recommend you do it as an either or and not as an and. An and is tough because then everybody needs to sign everything, which means basically no one can ever go on vacation, I suppose.
Exactly. Try and get two of us together.
Exactly. But if you do it as an either or, then anyone can act, and the family among themselves can more or less pick out the primary. So that way too, if you name more than one person, if something would happen to that one agent, you could have a problem, almost leading to if the principal would no longer have capacity to act and execute a new power of attorney, you may have to go to court and get a guardian appointed, which is something you definitely want to avoid if you can. It's very expensive.
So let's talk about the types of power of attorney. You were mentioning that in the beginning. You already talked about the limited or special type. Or let's go to the others that we want to think about.
Okay. Well, what I in almost all cases prepare is what we call a unrestricted or a general durable power of attorney.
There's that word, durable.
There's a word, durable, and that's something that most people do not understand, and that's because of it came about in a very odd way. The term and power of attorneys, as I stated earlier, are agency documents, and it stems from our English common law traditions that we brought over from England and the colonies. And if you think back in the old days, think of a master telling a servant to take a load of grain or vegetables to market. Well, what would happen if the master became incapacitated? Then that agency relationship would actually end. That carried over so that, and most people are incredulous when they hear this, that believe it or not, in the old days, if you did not have the word durable in a power of attorney, it would stop when the principal became disabled. Well, that's an awful result because that's exactly why you prepare, and that's why you want a power of attorney. So as a result, you had to specify that the power of attorney was durable, which in plain English means it survives the disability or incapacity of the principal. Now what happened is about 20 years ago the law in Pennsylvania did change. So you no longer have to have that durable in there, but you know how belt and suspenders attorneys are. We still like to have that term durable in there. But basically that's what it means.
All right. And so I'm looking ahead and picking, you mentioned talking about access to bank accounts so we can write checks and things. So that's financial, and then we also have health care, correct?
Correct.
So can you explain the abilities of both, and how do I do that?
Okay, well, when you prepare a power of attorney, again, your attorney will prepare that for you. It is very important to talk to the client and get their particular concerns about that. But most power of attorneys follow the basic pattern whereby you are naming one or more agents to handle your affairs for you if you cannot do so, whether you are disabled or whether you're unavailable or whatever. And the power of attorney is going to be fairly specific as far as the powers. And I've always maintained all a power of attorney has to say, to be in accordance with Pennsylvania law, is I allow my agent to do anything I could do. However, banks, investment companies, insurance companies, etc., want to see themselves specifically mentioned in the power. So as a result, it's grown into a relatively lengthy document. So again, from experience, it is important to have all of those things in your document.
And tell us so the power for health care or financial allows you to? Okay,
well, the health care, again, you can do any and all things in a general power of attorney that the principal could do. Now, once we move to healthcare power of attorneys, do you want me to head into that at this point, or do you have any other questions?
Before we do that, my question was also if we have that one person can be designated, one and or the other, to be that person, and they're working together.
Right.
Again, another document that can be changed. Let's say that those two individuals, one died, they aren't getting along, and you're a little concerned that so you can change that again.
Circumstances occur all the time. They are definitely what we call revocable. They can be changed all the time, and I have clients for many different reasons, either family changes, death or disability of an agent. There's all kinds of reasons, but again, the main thing is to keep them up to date and make sure they're accurate.
And in addition to the designations and whatnot, also to, now my mind just went blank again, to if they, we'll go on to living wills. I'm sorry, I had another question and totally forgot it. But with a living will is the third document. And so the difference is the power of attorney is planning ahead. This is what in general I can do for that person, whether it's financial or health care, but the living will is what type of document?
Okay, it is still a planning ahead. It's an advance directive, and which is the generic term. And what we do now, since Act 169 came in about 2007, 2008, we now do a document that is a combination healthcare power of attorney and living will. And just explaining both of those, a healthcare power of attorney, sounds rather trite, is a power of attorney for healthcare. We were talking about a
Yes.
financial power of attorney.
Right.
This is in the event you cannot make your own healthcare decisions. If you are in the hospital, laying on a, in the emergency room or whatever, obviously, and you cannot make your own decisions, you're designating someone to make those decisions for you. And that would be, they would be able to, for example, authorize your admission to a hospital or facility, hire any kind of doctors, nurses, caregivers, therapists, authorize medical and surgical procedures. It's very important, too, there's a law called HIPAA, which many people may be familiar with. It's all those privacy forms you have to sign when you go to your doctor. It's very important in the healthcare power of attorney to have a broad generic HIPAA power, because if you go into the hospital, for example, you will be seeing doctors and therapists and various healthcare professionals that you've never seen or heard about before. So it's very important to have that HIPAA power, which allows your agents, your family, to have access to your medical records, to talking to your physicians, because with the various privacy acts right now, if you don't have an appropriate HIPAA release, technically the hospital people, the medical people, it's very difficult for them to talk to you at that point.
And again, that's so important to have, because anything can happen to anybody at any time.
Absolutely.
So it's not just, although we're preparing and we're talking about it in terms of retirement planning, it really is an important document to be able to do and think about and talk to others. Let's, what I did want to mention though was, could you just quickly give us the difference between the living will and then a DNR? People will say to us, oh, I have a DNR.
Sure. Well, let me first of all, I think it's important to understand what a living will is, and then we'll look at the DNR. And again, it's a little bit of a confusing term. It's a, people sometimes confuse it with a regular will.
Right.
And a regular will during your lifetime. What it actually is a document that states this, that if you have reached the end of the line in life, you've reached what your physicians determine is an end-stage medical condition, that it is, barring something miraculous, you are not going to be able to recover from this. Then under those circumstances, what you are saying is, number one, I want to be kept comfortable. I want to have palliative care, I want to have hospice, anything of that nature to make you comfortable. Water, any treatments from water to morphine, anything in between. But number two, you do not want to be kept alive by machines or artificial means. You do not want things such as tube feeding, dialysis, artificial respiration, chemotherapies, things of that nature. So that's the living will. You yourself declare that these are my wishes, that I want to be kept comfortable, but I don't want these type of measures to be taken in the event my physicians determine that my time is naturally up. Now, what a DNR is, that's not something that you execute as an individual. That is something that's executed by the physicians and the healthcare professionals. And what they're saying basically is, and this is based upon information that the families provided to them, that in the event that you are out, you have a heart attack, stroke, or whatever, where you are unconscious, that you do not want to be revived. Okay, again, a totally different situation. That's, in my opinion, that's a dangerous situation, because there could be certain situations, I mean, if you have a 95-year-old little lady who weighs 95 pounds and she's in end stage, I don't think anybody wants somebody to be jumping on her chest trying to revive her, frankly. I certainly wouldn't want that to happen to one of my relatives. But in turn, I think most of us, if we're unconscious, we certainly want to be revived if there's any hope for us going on and living a fruitful life. So again, you got to be very careful with DNRs and understand particularly the differences between a DNR and a living will. Totally different.
Okay, and real quick, and we can, again, with a living will, because of life and circumstances and things change, we read about things, we can, again, change that living will at any time and should revisit it periodically to make sure that our feelings still remain the same as we did, and if we need to change that.
Oh, absolutely,
Right. Okay.
Absolutely. Yeah, any of those documents are revocable.
And then real quick, who should, in all of these, we'll wrap it up with the 3 key documents as we're thinking about our estate and retirement planning and getting some of the our affairs in order. I'm going to ask that we remember that the 3 of those documents, wills, power of attorney, and living will, are legal documents, can be changed at any time, should be reviewed periodically, and who should have copies of these things?
Okay.
And then we'll wrap it up.
What I normally recommend is, as far as the will, and there's different schools of thought here, but my office normally retains original wills so that people automatically know where they are. You know, you're dealing with the trauma and the heartbreak of a death of a loved one, and if you want to really magnify that exponentially, have a situation where nobody knows where the will is. Then that creates complete chaos and panic. So this way, people always know that the original will is with the attorney who drafted the will. And then, of course, we would give a copy of the will to the client. The power of attorneys, I would normally provide multiple copies of those, give most of them to the client, but I always keep 1 or 2 in my file. Likewise with the living will. They would go with the client. And I do normally recommend that the client not keep them in a safety deposit box. That doesn't really make much sense. Bad things happen at 2 a.m. Sunday morning and not necessarily 4 p.m. on a Wednesday. So you need to have accessibility, and you also need to make sure that the agents know where you're keeping those documents.
Great.
So again, that's very important.
Great. Well, thank you. That's all the time we have for our segment on estate planning. I want to thank again Attorney Bob Kreitz, who's with Roland Stock Law Firm, for providing this wonderful information on estate planning. And I hope that you seriously think about the future retirement planning, include considering making living wills, and power of attorney for yourself and others. Thanks for tuning in. Bye-bye.